Hello, I'm Jessica Ryan Keeney. I am the Department of Child Support Services attorney for two small Northern California counties. I've been practicing family law since December of 2009. What I'm about to say today is not legal advice. It is for educational purposes only. So today we're going to discuss the requirement or lack thereof of the court to provide a court reporter during contempt proceedings in child support cases. There are a number of cases dealing with the requirement that the court provide a court reporter to indigent parties in civil matters, and indigent parties are parties of limited means. And there are a number of cases dealing with the requirement that the court provide verbatim recordings of criminal proceedings or civil proceedings, but there were no cases found specifically dealing with the requirement that courts provide a court reporter in contempt cases. However, child support contempt cases are civil cases that are quasi-criminal in nature, and this basically means that there are criminal penalties if one is found in contempt of a child support order. In short, if a party is indigent and requests the court provide a verbatim record in a civil case, then the court must provide a verbatim record, either a court reporter or an electronic recording. This means that if the indigent party requests a court reporter in a child support contempt case, the court must provide a court reporter. However, if a party isn't indigent, then the court is not required to provide a court reporter in a civil case, including a child support contempt case, and the party must provide his or her own court reporter if he or she wants one. So the key here is that if the party wants a court reporter in a child support contempt case, then the party needs to request that court reporter if the party is indigent. And if the party isn't indigent, then they're going to have to provide their own court reporter if the court isn't providing the court reporter or an electronic recording. Government Code Section 69957 allows for electronic reporting in limited civil cases, misdemeanor cases, or infraction cases if there's no official reporter or an official reporter pro tem available to report the proceeding. In relevant part, California Rules of Court Rule 3.55 states that when a person gets a fee waiver, that fee waiver includes a waiver of court reporter fees for attending hearings and trials, and the clerk's fee. This is a waiver of the clerk's fee for preparing a transcript of an official electronic recording under Rule 8.835 or a copy of such an electronic recording. So a few important cases I picked out are In re Armstrong, and the citations to these cases are going to be in the description. So In re Armstrong is a case in which the court held that criminal defendants are entitled to a verbatim recording of their criminal proceedings, either court reporter or electronic recording, regardless of the defendant being indigent or not indigent, and regardless of defendant being convicted of a misdemeanor or a felony. Then People v. Turner is a case in which, it was a criminal case in which an electronic recording device was used to record the proceedings instead of a court reporter. And the appellate court, in short, held that Armstrong recognized that the use of a certified shorthand reporter was not the only way to provide an adequate record of a proceeding, and the appellant failed to show how his constitutional rights were violated just because his proceedings were recorded by an electronic device and not a certified shorthand reporter. And then Jameson v. Desta, this one prompted the rewriting of that California Rule of Court that I just wrote. Jameson v. Desta is a California Supreme Court case. This is a civil case in which plaintiff qualified for a fee waiver of initial court fees. The court held under California's I have trouble with this word. Basically under California's indigent persons doctrine and Government Code Section 68086 Subdivision B, a person who, because of limited financial resources, qualifies for a waiver of initial court filing fees is entitled as well to a waiver of fees for the attendance of an official court reporter at a hearing or trial. So, bottom line is, if you want a court reporter at your contempt hearing, you need to ask for one. If you are indigent, then the court needs to provide you a court reporter or an electronic recording if no court reporter is available. And if you're not indigent, the court may require you to supply your own court reporter. Thank you for tuning into this video today. If you have any questions, go ahead and leave them in the comments. Any answers will not be legal advice, but they always make for good conversations. And who knows, someone else out there may be wondering the same thing you're wondering. Again, none of this was legal advice today. This was for educational purposes only. Go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload future content, and we'll see you in the next video.